Chapter 23, Spendthrift Trusts, SS 360, Aversion to exemptions not statutory. Aside from statutory exemptions trivial in amount, the idea of the existence of rights of property of any kind in a debtor, which cannot be reached by creditors and applied toward the satisfaction of debts, is abhorrent to modern convictions of justice toward the creditor class, the personal liberty of the debtor being no longer in danger. There exists no controlling check upon his recklessness and improvidence. This is the source of the strong tendency, manifested in the courts, to strengthen, enlarge, and perfect the creditor's remedies and recourses against the property and interests of the debtor class. The plain purpose manifested in our modern law in extending relief to creditors is twofold. First, to enforce the creditor's equitable lien upon the debtor's property considered as a trust fund, and second, to inflict a species of negative punishment upon the debtor by depriving him of the personal comforts and enjoyments which result from the possession and use of property or accumulated wealth. There can be no spectacle more revolting to the mass of mankind, and especially in a community such as ours, than that of a bankrupt or insolvent reveling in luxury. It is opposed to a wise public policy that a man should have an estate to live on, but not an estate to pay his debts with, or that he should possess the benefits of wealth without the responsibilities. Chief Justice Denio said, "It is against general principles that one should hold property, or a beneficial interest in property, by such a title that creditors cannot touch it." The feelings of the general community were shocked at the dictum of Wright, J. in Campbell v. Foster, plus to the effect that the surplus of a trust fund created by a third party for the benefit of the debtor was not available to his creditors. The more recent opinion of Rapallo, J. in Williams v. Thorne, holding that, whether the trust relate to realty or personalty, the surplus income of such an estate beyond what was needed for the suitable support and maintenance of the Sestuique trust and those dependent upon him, could be reached by a creditor's bill, was greeted with satisfaction. An effort, however, has been made to close another source of possible relief to creditors by the class of cases already referred to, and which will presently be considered more at length. First, however, we will glance at the authorities which discuss the rights of the parties in cases where property has been conveyed with a restraint imposed upon its alienation, or an attempt has been made to vest it in the grantee without subjecting it to liability to his creditors. SS 361. Restraints upon alienation. The theory of the law is that no person shall be permitted to enjoy or hold any interest in property to which the incidents of ownership, i.e., the right of alienation and liability to the claims and remedies of creditors, do not attach a condition or proviso in a grant or devise that the land shall not be subject to alienation, attachment, or levy is treated as void. The policy of the law will not permit property to be so limited as to remain in a party for life, free from the incidents of property, and not subject to his debts. SS 362. Repugnant conditions. Restraints upon either voluntary or involuntary alienation are not favored in the law, and are defeated upon another ground. In DePaster v. Michael, after a careful review of the authorities, the New York Court of Appeals observed, upon the highest legal authority, therefore, it may be affirmed that in a fee simple grant of land, a condition that the grantee shall not alien, or that he shall pay a sum of money to the grantor upon alienation, is void, on the ground that it is repugnant to the estate granted. So in Bradley v. Peixoto, the court say that it is laid down as a rule long ago established, that where there is a gift with a condition inconsistent with, and repugnant to such gift, the condition is wholly void. A condition that tenant in fee shall not alien is repugnant. For in Mandelbaum v. McDonnell will be found an elaborate review of the cases and an exhaustive consideration of the question. The court conclude that the only safe rule of decision is that which prevailed at common law for ages, to the effect that a condition or restriction which would suspend all power of alienation for a single day is inconsistent with the estate granted, unreasonable, and void. In Blackstone Bank v. Davis, a leading and important case, it appeared that one Davis devised to his son the use of a farm of 120 acres, with a provision that the land should not be subject or liable to conveyance or attachment. The plaintiffs recovered a judgment against the divisi, and levied an execution upon the premises as being land held by the defendant in fee. The court said, by the devise of the profits, use, or occupation of land, the land itself is devised, whether the defendant took an estate in fee or for life only. is a question not material in the present case. The sole question is whether the estate in his hands was liable to attachment and to be taken in execution as his property. The plaintiffs claim title under the levy of an execution against the defendant, and their title is valid if the estate was liable to be so taken, that it was so liable, notwithstanding the proviso or condition in the will. The court cannot entertain a doubt. SS 363 in Walker v. Vincent, the testator devised certain real estate to his daughter and to her legal heirs forever, upon the express condition that she should not alien or dispose of the same, or join in any deed or conveyance with her husband for the transfer thereof, during her natural life. The court held the condition void, and that a fee simple estate was devised, and said, it makes no difference that the testator has expressly withheld one of the rights essential to a fee simple, for the law does not allow an estate to be granted to a man and his heirs with a restraint on alienation, and frustrates the most clear intention to impose such a restraint, just as it allows alienation of an estate tail, though a contrary intent is manifest, and it would be exceedingly improper in any court, in construing a devise to a man and his heirs, to endeavor to give effect to the restraint upon alienation by changing the character of the estate to a life estate, with a remainder annexed to it, or with an executory devise over. In Hall v. Tufts, the testator devised certain real estate to his wife for her life, and the remainder of his estate, whether real or personal, in possession or reversion, to his 5 children, to be equally divided to and among them, or their heirs, respectively, always intending and meaning that none of his children shall dispose of their part of the real estate in reversion before it is legally assigned them. The court held that the children took a vested remainder in the real estate given to the wife for her life, and that the clause restraining them from alienating it before the expiration of the life estate was void. SS 364, Nichols v. Eaton. The point actually involved, the principle embodied in Nichols v. Eaton, and more especially the language employed by Miller, J., in delivering the opinion of the Supreme Court in that case, have provoked extended discussion and sharp criticism. The importance of the case seems to call for an extended statement of the facts involved. It appeared that property had been devised to trustees with directions to pay the income to the children of the testatrix in equal shares, and on the death of each child, his or her share was to go over, if the sons respectively should alienate, or by reason of bankruptcy or insolvency, or any other cause, the income could no longer be personally enjoyed by them respectively, but would become vested and payable to some other person. Then the trust as to such portions so divested should immediately cease and determine, in that event, during the residue of the life of such son, the income was to be paid to his wife or child, and in default of such persons, to be added to the principal, and further, in case, after the cessation of said income as to my said sons respectively, otherwise than by death, as hereinbefore provided for, it shall be lawful for my said trustees, in their discretion, but without its being obligatory upon them, to pay to or apply for the use of my said sons respectively, or for the use of such of my said sons and his wife and family, so much and such part of the income to which my said sons respectively would have been entitled under the preceding trusts. In case the forfeiture hereinbefore provided for had not happened, one of the sons became a bankrupt, and his assignee in bankruptcy brought a bill against the trustees to have the income of the son's share applied for the benefit of creditors. Mr. Justice Miller, in the opening sentences of his opinion, observes that the claim of the assignee is founded on the proposition that a will which expresses a purpose to vest in a divisi either personal property, or the income of personal or real property, and secure to him its enjoyment free from liability for his debts, is void on grounds of public policy, as being in fraud of the rights of creditors, or as expressed by Lord Eldon and Brandon v. Robinson. If property is given to a man for his life, the donor cannot take away the incidents to a life estate. There are 2 propositions, continues the learned judge, 0 be considered as arising on the face of this will as applicable to the facts stated. Does the true construction of the will bring it within that class of cases, the provisions of which on this point are void under the principle above stated? If so, is that principle to be the guide of a court of the United States sitting in Chancery after reviewing the English authorities? The opinion continues, conceding to its fullest extent the doctrine of the English courts, their decisions are all founded on the proposition that there is somewhere in the instrument which creates the trust a substantial right, a right which the appropriate court would enforce, left in the bankrupt after his insolvency. and after the cessor of the original and more absolute interest conferred by the earlier clauses of the will. This constitutes the dividing line in the cases which are apparently in conflict. Applying this test to the will before us, it falls short, in our opinion, of conferring any such right on the bankrupt. Neither of the clauses of the provisos contain anything more than a grant to the trustees of the purest discretion to exercise their power in favor of testatrix sons. It would be a sufficient answer to any attempt on the part of the son in any court to enforce the exercise of that discretion in his favor, that the testatrix has in express terms said that such exercise of this discretion is not in any manner obligatory upon them. Words repeated in both these clauses, to compel them to pay any of this income to a son after bankruptcy, or to his assignee, is to make a will for the testatrix which she never made, and to do it by a decree of a court is to substitute the discretion of the chancellor for the discretion of the trustees, in whom alone she reposed it. Thus far we cannot but consider the case as correctly reasoned and decided, since a gift of a life estate or interest, with a proviso that it shall go over to a third person upon alienation, voluntary or involuntary, by the life tenant, is considered valid. We can formulate no well-founded objection to such a transaction. Probably the earliest case in which the point is so held is Lockyer v. Savage, decided in 1773. But the question seems now to be no longer a matter of dispute. Probably the earliest case in which the point is so held is Lockyer v. Savage, decided in 1773. But the question seems now to be no longer a matter of dispute. SS 365. The dictum in Nichols v. Eaton. The court, however, seemed disinclined to limit the discussion to the questions before it, referring to the implication in the remark of Lord Eldon, already quoted. The court were unable to see that the power of alienation was a necessary incident to a life estate in real property, or that the rents and profits of real property, and the interest and dividends of personal property, might not be enjoyed by an individual without liability for his debts attaching as a necessary incident to such enjoyment. The opinion continues. Nor do we see any reason, in the recognized nature and tenure of property and its transfer by will, why a testator who gives without any pecuniary return, who gets nothing of property value from the donee, may not attach to that gift the incident of continued use, of uninterrupted benefit of the gift during the life of the donee, why a parent, or one who loves another, and wishes to use his own property in securing the object of his affection, as far as property can do it, from the ills of life, the vicissitudes of fortune, and even his own improvidence, or incapacity for self-protection, should not be permitted to do so, is not readily perceived. The cases cited in support of the views of the court are chiefly from Pennsylvania, and unfortunately, as we think, close with the well-known New York case of Campbell v. Foster. This case, as we have already seen, contains a dictum to the effect that the interest of a beneficiary in a trust fund created by a person other than the debtor is not available to creditors. But, as heretofore shown, this dictum is expressly repudiated by Rapallo J. in delivering the opinion of the New York Court of Appeals in Williams v. Thorne, and the principle in support of which the case is cited in Nichols v. Eaton is proved never to have been the law of that state. Nichols v. Eaton embodies a dangerous and startling dictum. If the question whether or not it was permissible, aside from the rules of law establishing the tenure by which property is held and transferred, to allow a debtor to enjoy an interest in property free from the claims of creditors, were an open one, we should certainly answer that such a policy was neither judicious, safe, nor wise. This conclusion is not necessarily rested wholly upon the theory that such a vesting of property in a debtor is a fraud upon creditors, but rather that property, by the rules of law, includes not only the right of enjoyment, but also the right of alienation and liability for debts. While it is true that the owner of property may, while he owns it, use it as he likes, yet he should not be permitted to limit or control its use after he parts with it. These trust estates and incomes are in the opinion likened to statutory exemptions. The analogy is considered perfect. The creditor, it is said, has no right to look to either of these sources for satisfaction of his claim. We challenge the justness of the analogy and question the correctness of the rules sought to be formulated from it. Statutory exemptions are trivial in value. They do not clothe the debtor with indicia of wealth, or furnish him with comforts or luxuries. It would be inhumane to permit the creditor to take the insolvent's clothing from his back, the food from his table, or the bed from his house, it is equally against a wise public policy to deprive the professional man of his library, the mechanic of his tools, or the teamster of his horses, for by so doing the insolvent would be pauperized and perhaps rendered a public charge, and the possibility of repairing his ill fortune by future industry irretrievably lost. These exemption statutes, so universal in their operation, reflect the charitable sentiments of a noble and generous people, and exhibit a willingness on the part of the lawmakers to extend a protecting hand to unfortunate struggling insolvents. We deny that the kindly spirit which inspired this humane legislation can be tortured or perverted so as to subserve the purpose of shielding vagabond spendthrifts from the remedies of their creditors. SS 366. The correct rule. The true rule should be that whatever a man can demand from his trustees, that his creditors can demand from him, until haste be. Bradford, it appeared that the devise was to T and trust to pay the income to H for life. Anticipation or payment to assigns was prohibited, the income being intended for the sole and separate use of H. An assignee of H for the benefit of creditors was awarded the income for the life of H, the court said. This has been the settled doctrine of a court of chancery, at least since Brandon v. Robinson, and, in application to such a case as this, is so honest and just that we would not change it if we could. Certainly no man should have an estate to live on, but not an estate to pay his debts with. Certainly property available for the purposes of pleasure or profit should be also amenable to the demands of justice. In Bramhall v. Ferris, Comstock, J. observed that if a bequest is given absolutely for life, with no provision for its earlier termination, and no limitation over in the event specified, any attempt of the testator to make the interest of the beneficiary inalienable, or to withdraw it from the claims of creditors, would have been nugatory. Such an attempt would be clearly repugnant to the estate in fact devised or bequeathed, and would be ineffectual for that reason as well as upon the policy of the law. For and where trustees held property with power to apply such portion of it as they saw fit to the education and maintenance of a beneficiary until he should reach 25 years, and then to convey the principal with all accretions to him, the power being given to the trustees in their discretion to convey the estate to the beneficiary before he was 25 years of age, it was held that the beneficiary's interest was liable for his debts. 5. SS 367. Broadway Bank v. Adams. We will not further pursue this subject except to notice an important case in Massachusetts. Broadway Bank v. Adams. The object of the bill was to reach and apply to the payment of the plaintiff's claim the income of a trust fund created for the debtor's benefit by the will of his brother. Briefly, the will gave $75,000 to executors in trust to pay the net income to the debtor semi-annually during his natural life, the payments to be made personally or upon his order or receipt in writing, in either case free from the interference or control of his creditors. My intention being that the use of said income shall not be anticipated by assignment. The income after the debtor's death was to go to his wife and children, and upon the death or remarriage of the wife, the principal and accumulations were to be divided among the children. Manifestly, the intention of the testator was that the income should be free from the claims of creditors, and that the court should be unable to compel the trustee to divert the income unless the provisions and intention were unlawful. The court observe at the outset that the question whether the founder of a trust can secure the income of it to the object of his bounty, by providing that it shall not be alienable by him or be subject to be taken by his creditors, has not been directly adjudicated in Massachusetts, but say that the tendency of the decisions has been in favor of such a power in the founder. The reason of the rule that a restriction upon the power of alienation is void because it is repugnant to the grant is said not to apply to the case of a transfer of the property in trust, as by the creation of the trust the property passes to the trustee with all its incidents and attributes unimpaired. The trustee takes the whole legal title to the property. With the power of alienation, the cestui quae trust takes the whole legal title to the accrued income at the moment it is paid over to him. Neither the principal nor the income is at any time inalienable. It is conceded by the court that from the time of Lord Eldon the rule has prevailed in the English Court of Chancery, to the effect that when the income of a trust estate is given to any person for life, the equitable estate for life is alienable by, and liable in equity to the debts of, the cestui quae trust, and that this quality is so inseparable from the estate that no provision however express, which does not operate as assessor or limitation of the estate itself, can protect it from his debts. The English rule, the court observe, has been followed in some of the American cases, while other courts have rejected it, and have held that the founder of a trust may secure the benefit of it to the object of his bounty, by providing that the income shall not be alienable by anticipation, nor subject to be taken for his debts. Morton, C.J., said, the founder of this trust was the absolute owner of his property. He had the entire right to dispose of it, either by an absolute gift to his brother, or by a gift with such restrictions or limitations, not repugnant to law, as he saw fit to impose. We do not see why the founder of a trust may not directly provide that his property shall go to his beneficiary with the restriction that it shall not be alienable by anticipation, and that his creditors shall not have the right to attach it in advance, instead of indirectly reaching the same result by a provision for assessor or a limitation over, or by giving his trustees a discretion as to paying it. He has the entire justus ponendi, which imports that he may give it absolutely, or may impose any restrictions or fetters not repugnant to the nature of the estate which he gives. Under our system, creditors may reach all the property of the debtor not exempted by law, but they cannot enlarge the gift of the founder of a trust and take more than he has given. This is probably the most advanced statement of the objectionable doctrine. Reference is here made to cases like Broadway Bank v. Adams and to the dictum in Nichols v. Eaton, not as embodying salutary rules or wise principles of law, but rather to record a protest against the existence and growth of a class of cases which at present are comparatively few in number, the creation of an aristocracy of prodigals, who can dwell in luxury and defy their creditors, brings the administration of justice into disrepute, and has a demoralizing influence upon honest people. The creditor is unjustly deprived of the power to compel his debtor to forego the comforts and luxuries of wealth, or to feel the privations incident to insolvency. The tendency of these cases must be checked by legislation, or the sober second thought of the courts. The doctrine will never be tolerated by the American people. SS 368, Spendthrift Trusts in Pennsylvania. It is common to refer to Pennsylvania as the birthplace and stronghold of the doctrine of spendthrift trusts, yet Chief Justice Agnew said, in Overman's appeal, it is exceptionable in its very nature, because it contravenes that general policy which forbids restraints on alienation and the non-payment of honest debts. A trust to pay income for life may last for the longest period of human existence, and may run for 70 or 80 years, while the law simply tolerates such a trust. It cannot approve of it as contributing to the general public interest. Property tied up for half a century contributes nothing to the general wealth, while it is a great stretch of liberality to the ownership of it to suffer it to remain in this anomalous state for so many years after its owner has left it behind him. Clearly, it is against public interest that the property of an after generation shall be controlled by the debt of a former period, or that the non-payment of debts should be encouraged.